This is Sachin Sawant, your UK immigration lawyer, trying to put. Sorry about the delay. Okay, there's a question from member TD. Can skilled workers go outside the UK for 120 days at a time? 120 days at a time. Should I need to report to anyone, which includes holidays, work from India, and paternity leave? I had approval from the manager. 120 days at a time. Uh, Extended period of time that you have worked outside the UK, I think if it is 120 days and that is at a stretch, it is always good practice for the employer to do a reporting because the work location has changed. If that is not your normal work location, it's always a good practice that the employer should do it. There is no obligation on you, but for employers compliances, it is a good practice because it is about 3 months or so. So that is my advice. Okay, I'll take the questions on the channel. Okay, so and any other questions? Okay, Hafiz, thank you for being a bronze member. Okay, and I have a question here on the channel. Can I get sponsorship after EU settlement scheme UK? So if your EU settlement scheme application has been refused, it depends whether you have Section 3C leave still valid. Only then you can switch within the UK. Yes, you can get sponsorship, but you may have to do an entry clearance application if you don't have valid Section 3C leave on the date of your skilled worker application. Yes, you can get sponsorship. The question is, can I get sponsorship after EU settlement scheme? Which I'm implying that your EU settlement scheme is refused. Yes, you can get sponsorship. That is my straight answer. So next question, Nurahat, with this new rule, can I work in as a Tesco or a superstore? Yeah, this is a common question that I get for the supplementary employment for skilled workers, the 20 hours that are allowed. Uh, you can only work in a skilled occupation. And Nurahat has asked, can I work in ASDA Tesco, so which is a retail job? You cannot do that job. Retail sales jobs are not termed as skilled occupations, so you won't be able to do those jobs. Next question I have applied for UK standard visa, but I have been refused. Okay, it's a long one. I'll try to summarize it over here. I had applied for UK standard visa, but I had been refused. I had been refused. I haven't declared any dependent in my home country or sufficient ties to home country. Then let's say I intend to stay for 10 days. Watching. Okay. Okay, there is a question from a viewer about visitor visa being refused. It's a common refusal reason where I think there are some salaries deposited of 1850 in your bank account and you don't have much connections to the UK. There are several reasons that they have refused your application. You should take proper immigration advice. You can book a paid consultation with us. That is what my advice is. So it is quite detailed. So there are several factors. Visitor visas are almost the most difficult ones to get if you don't have any much ties back home. So next question, live. Can I get a refund of my IHS having worked as a support worker for 6 months with my family? Yeah, if you decide to leave the UK and you are not, so the only way the IHS works, I have detailed that in that detailed video of IHS refunds that you can watch, is if you pay new IHS, only then you get back the previous IHS back proportionately, if that is the case. If you don't, if you are applying for a new visa and paying a new IHS, then you may be eligible for the IHS refund. But if you're not making any application, you want to leave the UK or anything, you will not get any refunds. That is how Home Office works. Abdul Rahman, can I give a different role to skilled worker in same company like graphic designer? Yes, in the same company you can change the job, but make sure that if the job code is changing, if the job code is not changing, you may have to do a reporting through the sponsor management system and tell the Home Office what is changing, salary, role, anything. If the job code is not changing, but if the SOC code is changing, let's say your job code was 1234 and it is changing to 1236, then you have to make a new visa application. You have to issue them a new certificate of sponsorship and they have to make a skilled worker application as good as they are changing an employer or something like that. So that is what the rules require you to do. Okay, I'll take more questions on the channel that I have. Let's see. Okay, Silva. Thank you for being a member, Silva. Your question is after 5 years on skilled worker visa, can I apply ILR before visa expires? Is it enough time to apply ILR? What factors do I need to remember? Example, like in the UK test. Yes. So summarily, you can apply within the last 28 days of completing your 5 years. That is when you can apply for indefinite leave to remain. And yes, you need to pass your life in the UK test. English language you may have already met because you're on a skilled worker visa. And that's its absences, not more than 180 days in the last 5 years. That is one of the crucial ones. You need to get a letter from your employer confirming your employment. The format and all should be on the website, I think. So there is a list of documents on our website. You can go through that. And yeah, the employer has to confirm that you are required for the job for the foreseeable future. One very important thing, if you join the skilled worker area under the old rules, the rules before 4th April 2024, then the employer may have to increase the salaries marginally. So for example, if your base, I have explained that in the skilled worker salary guide video, you can watch that video. But if your basis of your permission of the skilled worker was on the basis of 26,200, which was the base before, uh, for the old rules, currently the base has shifted to 29,000. So accordingly, your employer has to work it out. You should take maybe immigration advice from a lawyer, and if you want to calculate the exact numbers, and they have to increase your salaries proportionately if they are not meeting those requirements. Okay, next. When I was 17, student visa. Okay, so someone has asked a question about private life visa. So I came to the UK when I was 17 on a student visa. It lasted for 3 years, 17 plus 3. Okay, I just applied for graduate visa, making everything 5 years. I would be older than 22 plus less than 25. I don't think you will qualify for the private life visa. I am very positive, but anyways, I will check it. He's asking whether he would qualify for a private life visa. Let me check the rules. Quickly checking the rules. Yeah, so one of the requirements for the private life visa is if you are between 18 and 25, you should have spent half of your life in the UK. I don't think that is your case because you came to the UK at the age of 17 and you are 22. So yes, you will not qualify for the private life visa. Any answers that I'm giving, this should not be construed as immigration advice. Remember that this is my disclaimer. You should always take proper immigration advice from a lawyer. You can book a paid consultation with us and we can advise you on your specific situations. Okay, next one here. One question I have from Zahara. Zahara and kids. Can you still apply without BIP or valid password? It's not working with the Home Office reference only. With the Home Office reference, it does work. I have seen that. I have done with UANs. I have done it with GWF reference. The question is about eVisa. Can you create a eVisa account, UKVI eVisa account, whatever they call it? Yeah. So with your BRP card, passport, you can create with your Home Office reference. I have seen that. You can maybe speak to an immigration lawyer, take advice, or speak to there is a eVisa web chat. If you Google search for a web chat, Home Office has that and tell them that you are having that issue. They may be able to help out. So, or else speak to an immigration officer and they may help out with setting you up or may find alternative solutions. There are several system issues going on with the eVisa things also. So, yeah, speak to the Home Office before through that web chat or call the Home Office. So, that is my suggestion. Next question, Niharika. For Hi, for salary requirements, only basic pay is considered to cross minimum salary threshold, which are part of salary. Is only usually only basic pays, fixed component that will be paid every month. Doesn't matter what you call it. You can call it basic plus bonus, anything and everything. Only that can be considered for a skilled worker salary. Anything that is variable or car allowance, they cannot be considered, or housing allowance, those cannot be considered towards skilled worker salary calculations. So, to answer your question briefly, only basic pay can be considered, not other benefits. Okay, no more questions. Okay, so Abdul Rahman, our skilled worker visa is work. Our skilled worker is working 37 hours per week. Is an office manager, and we have a graphic designer role available in the company. Can they legally work in this additional role as well? Additional role as well. 20 hours. Yes, if they are working 37.5 hours, so I will answer it in two parts. One is they can keep the skilled worker, keep on working as office manager for that 37.5. For the rest 20 hours, they may be able to work for that other role, graphic designer. If you want them to move completely the role to the full-time role as the graphic designer, they have to apply again. You have to give them a new course as a graphic designer, which is a different job code from an office manager. I'm pretty sure about that. And they have to apply for a skilled worker visa, which is approved as a graphic designer. Okay, so Sidra, Assalamu alaikum. Yes, hello. So, Dilatronic, a member has asked a question. If a company is unable to provide cost within the next 2 months, they are currently working on it. I need to leave the UK. In that case, should I pursue a defined cost or an undefined one? So, yeah, the member's question is, I think he's waiting to either switch to a skilled worker visa or change employers. He wants to file a skilled worker visa. Your cost is not yet issued. Maybe the company has filed for additional allocations and they are waiting for it. That's what it seems from your message. So if they don't get the allocations before your current permission expires, whatever that permission is, yes, you will have to leave the UK and then apply with a defined certificate of sponsorship from outside UK. That is one option. Secondly, if your employer is already in the process of, let's say they've applied for a sponsor license or they've applied for additional courses, one of the options to do it through lawyers, which we have done it many times successfully, is we file the application to Home Office, skilled worker application before your current permission expires, latest by the last date of your current permission. Ask the Home Office to keep the application on hold, give them any evidence of the sponsor license filing or the cost allocation requested, and ask them to keep the application on hold. That way, your Section 3C leave is protected. They also have the option of refusing it. I've covered this part in many other videos as well, because not giving a cause is a validity requirement. They may declare it as invalid. So if you are doing the pending cause application, always do it through legal representatives, either through us or anyone else, but have proper legal representations. And once the course is approved or the license is approved and the course is ready, then we forward it to Home Office, ask them to continue processing, and they do that. So it has been done every time. They have never declared the applications as invalid in practice. So that is one thing that you can consider. Either leave the UK, apply with a defined cost, or apply from within UK through a lawyer and ask them to keep it on hold and provide it subsequently, the costs. So that is my answer. So you are asking, please answer questions. I have answered this. I don't know where your other questions are. You can ask it on any other videos, and or you can come in the live and ask me. That is fine. Thank you for providing. Okay, okay, that is done. Thank you. Thank you. Okay, to apply for skilled worker visa, dependent visa from outside. Live question from TD. To apply for a skilled worker visa, dependent visa from outside UK, should I provide any address proof of the main applicant's address? Address proof of the main applicant's address. No, there is no such requirement. There is nothing. You can be living anywhere in the UK. Home Office doesn't care. Yeah, so the dependent is applying. Address is not a matter in question. Okay. So where was that one? Okay, another live. Should answer your question in one of your videos. Please answer. Okay, can you ask the question live over here? Please type it here. I will try and cover it. It's very difficult on YouTube. The problem is there are considerable subscribers and there are a lot of comments on the channel. Many times, if you write on the replies or on some videos on replies and replies, it doesn't flow through. It is my challenge. I'm trying to find all the questions, but I have a challenge. I'm just trying to scroll and sort and find out whatever questions I can. So if you are live, please type it over here. Yeah. Okay. Why is there delay in costs? No. Okay. So it's been 4 months. Okay. 3 days ago. So it's been 4 months that I'm in the UK on a skilled worker visa, but the company has not, they're not giving me job. During these 4 months, I don't have to do any job. It's been 4 months that I'm here without paying. Okay, so this is a common situation. In the last 2, 3 years or so, there have been a lot of frauds going on. Skilled worker visas have been sold, care, healthcare area, other retail job areas, and whatever that is has happened. So there are many situations in the individuals in the UK who are on skilled worker visas. Employer is not giving them any work. So the question from Rashid but is that it's been 4 months. He's on a skilled worker visa in the UK, but the company has not given him any work. No taxes paid, no salaries paid to him, nothing doing. So his question is, I'm here without paying. What is the impact of not doing a job? Paying the tax. So paying the tax, yeah, it's not that much of a matter because if you're not doing a job, it's not your problem. So that's how I would put it. If, but yeah, if so, the way I would put it is not being paid, not doing the job, it is more the employee's issue because they are required to fire you, cancel your visa, do whatever if they cannot give you work. But if they are keeping you, stay your visa still live, uh, you not getting the work from the employer or not being paid is not your fault. Till the time your skilled worker visa is alive, it is not cancelled, you are perfectly fine and you are physically present in the UK. If that is happening, you are legal in the UK. No one can, yeah, so you are not breaching any immigration laws. If your employer who has promised the work is not giving you, the only thing that you can do is you can try to find another employer, another sponsor, try to switch to them as soon as possible. But what effect does this have? Let's say I'm taking this 4 months problem, 4 months, no salary, nothing. So it does not affect your visa per se. It doesn't affect your ILR also. Subsequently, let's say you get another employer, you work normally in the skilled worker with another employer, everything is fine, you complete your 5 years, that 4 month period is not going to have any impact because you had valid permission during that period. This is what I am telling you from the rules and the practice of home office as of today. That's the only thing I can say. In future their practice may change, I don't know about that, but as of today home office has not been concerned, or they are not checking if you were not working for a period of time, unless it is too long or something, unless they know something about it. But I have not seen home office researching or reverse working or trying to create problems with this. At the point of ILR, they only check, they want your latest payslip issued within last one calendar month, latest bank statement showing the payment, letter from your employer. So those are the three ones to confirm your job to get ILR. I'll take the live questions. Yeah. So it's not going to impact on the ILR. Leaving the UK and coming back to the UK, yes, that may be affected. I may have covered this on other videos, I'm pretty sure, in details where people have lost their job and all. You can watch those videos. But yeah, I would advise against traveling outside the UK. If you come back, immigration officer may query you, they may cancel your visa on the border also. They have that right. So those are my three answers that I can say. Stay put, look, keep on looking for other employer. That's what my advice is. Okay, so that's your answer. Okay, Sidhya, I have answered you. Thank you very much. I'm taking the questions. I'm doing a supplementary 20 hours a week job that my employer has sometimes offered 52 hours a week for this employer because my sponsor has not yet given a single work. Yeah, so working for supplementary employment more than 20 hours, I would advise against this. This may be a problem at the point of ILR. Home Office has not been taking this as a negative or hasn't been beating up people on this, but I know that towards the end of 5 years, rules, the practice may change. Rules, I don't think rules will change much, but the practice of home office may change if they see you abusing the 20 hours instead of that you're working 52 hours, which is quite considerable. They may consider it as compliance breach and it may have an effect on your ILR or something like that. So that's my advice. Don't do that. Maybe your dependent has full rights to work. The dependent can work if you can work it out that way. This new supplementary employer as estimated. Okay. Yeah, but I would advise if it has happened once in a while, 50 hours work, yes, but you need to stop doing that. That's my advice. I have to stick to the immigration rules because home office may change their approach at any time they may consider this compliance breach and they just start refusing applications or taking some compliance action. So just be mindful of that. So there is a live question. Can anyone switch from healthcare to accountant in UK? Accountant in UK. Yes, you can switch from one skilled worker visa to another skilled worker visa. Both are skilled worker areas. So yes, you can. Okay, so this one is done. Okay, the question from Immaculate is thanks, Francis. Okay. Okay. Does the share code indicate the end of stay of an individual in the UK even without an email from the Home Office? I don't get the even without an email from the Home Office, but yes, the share code will indicate if someone is doing to do a trying to do a right to work check or even right to rent check. It will give them the end of permission. It may or may not show the type of permission. Home Office is trying to change that for certain types of visas because that is not of concern to your employer or your landlord or something. For example, if you have some domestic violence, ILRDV or something. So they may not show the type of leave. They may just show you have permission till this particular date. But yes, it will show an end date of your permission, the right to work or the share code or any way you are checking the rights. Next question I have. I'll be live for further about 10 minutes or so, 48. About 10 minutes I'll be live now. So So I was supposed to get my skilled worker visa, but my IELTS results came on 5th of April this month. Okay. Once I submitted my documents, I'm taking some older questions. I haven't been live for a while, so I will try to bring them to present and try to answer them in the best way possible. So I was supposed to get my skilled worker visa, but my IELTS results came on 5th April. Once I submitted my documents to the lawyer, now they said they are not able to proceed my visa. Okay. I think you already worked with some lawyer. I'm not sure what you are trying to ask me. Try to anyways understand it. So I was supposed to get my skilled worker visa. Okay, we were filing for it. Your IELTS results but came on 5th of April. Okay, so okay, you're talking of the old rules and the new rules. Yeah, but anyways, it has become redundant. So maybe I will refrain from getting into it. It's not no more relevant now. No more live questions. Okay, another question I have from someone is I have a question. If I will apply for skilled worker visa from Italy, I have a sponsor who is trusted. Should I choose a 3 year or 5 year visa? 3 year or 5 year, it depends on you what you need to decide. This what you need to apply. 5 year visa will double the double the visa fees also, and 3 year application will be half the fees. Immigration health surcharge will be calculated accordingly. 3 year visa will be 1035 into 3, or 5 year visa will be 1035 into 5. And difference in circumstances, what may happen, redundant. If you are made redundant, yes, then you may have to switch employers and you have anyways lost the visa fees. But yeah, the IHS may be refunded if you apply and switch to another employer, pay a new IHS. So the IHS is refundable if you are made redundant and you move other employer. If you leave the UK, you don't get any IHS back. So or they are equal on all other terms. It's only the money aspect of things, whether you apply for a 3 year visa or a 5 year visa. So, Siddhar Rashid, what is your question? Can I apply for security badge as part-time job? However, I am skilled worker visa holder. Part-time job security badge. I am not too sure if security badge. You can apply for a badge, but I don't know if you can work as a security officer or something. Let me check. I don't think security officer would be in a skilled worker. Okay, let us see. Protective services. I'm seeing. I see security manager under the skilled occupations. This is 3319 job code. If this is what you're doing, yeah. So operations manager, private. Security manager is one of the protective services associate professionals not elsewhere classified. Protective services. So maybe if this is what you're doing, yes, then you may be able to get the badge and start working as a security manager. I don't know what exactly that job does, but security manager is in the skilled occupations. It's 3319. That is the job code. Francis, next question. I'm coming to the UK as a dependent to a skilled worker. Can I get a job as IT and get a course? You're coming as a dependent. Can I get a job as IT? Yes, you can get a IT job. That is fine because you are a dependent. You have full rights to work. You're a dependent of a skilled worker. You have full rights to work in the UK, including doing business, etc. So, and get a course. Why do you need a course? I'm not sure. If you want to switch and you want to become the main applicant, then you should get a course. That's my advice. Or if both of you want to have your own independent skilled workers, you don't need a course. Basically, you can just work with your dependent partner visa. Thank you, Sidra. Thank you. Okay. Any other questions? Let's mark this. Okay, another question I have. I don't know if I'm. Yeah, this is another common question that I'm being asked. Yeah, if you have so you don't have a valid visa, you have a skilled worker. So the question is, Chin, yeah, I came to India after leaving my job. So you already left your job in March 24. I don't know if my employer informed Home Office, so you don't know whether your visa is cancelled, curtailed by Home Office, but I didn't receive any email from them. Check my right to work. So if you check your right to work, if your either your employer has not reported to Home Office or Home Office has not come to picking up and cancelling your visa. Whatever is the reason, your visa is still showing valid. You have left the UK. Your question is you want to come back to the UK. I don't think I would advise against coming back to the UK. It is highly likely that the immigration officer may question your query and they may cancel your visa on entry only because you are no longer working for your employer for quite a period of time and your job has ended. So visa, just having the visa at the back end, the permission only helps you if it is valid. If you are still living in the UK, you are legal in the UK. But if you leave the UK and try to re-enter, that permission may be cancelled by an immigration officer. Please share the link extra 20 hours for skilled workers. Share the link extra 20 hours for skilled workers. Yeah, you can Google search and go on to skilled worker visas and find it out. Sorry, I cannot. This is not immigration advice. You have to pay for an immigration advice, book a consultation. I can give you all the links in that. But if you want to find the link for that 20 hours, look for the skilled worker occupations, skilled worker visa. Under that, it does give you supplementary employment, and then it gives you skilled occupations link over there. So next questions. Months ago, 7 months. Okay, 245. I will wait for about 2 minutes. If any live questions come, I will take them. No more live questions. And yes, thank you for this live. I really appreciate. Thank you, Didi. Have a good day. Okay, if there are any more questions, you can ask me here. General general things that I can address by the time any questions come. E-visas, yes, there are some issues and all. You have that web chat to talk to Home Office. You can create accounts. I have created several accounts for clients and all. It's quite okay. BRP production has stopped by September and they stopped any replacement BRP production. By October 31st, they stopped all BRP productions. So, to the best of my knowledge, you should not get any BRPs today. Yeah, so no BRPs any longer for anyone. That's how I understand it. Okay, that's what Home Office has confirmed. What is the timeline to update the e-visa? Timeline to update the visa. I don't know exactly what you're asking, but yes, you should create an eVisa account as soon as possible if you have a BRP. That's my first answer. Timeline to update e-visa. Yeah, if there is anything, let's say you got a new passport that you are going to update, as soon as you get the passport, you should update it. Or if you are having any travel plans, your e-visa and all will only have effect when you're trying to enter the UK. If you're trying to board a plane and they're trying to see your passport, put in the system and all of that. Subsequently, it would be connected into the check-in also. So that API, Home Office is building that application, whatever interface they call it, API, through which when you check in from outside the UK, automatically at the point of check-in only, it will check your permission status. And I think it may not allow you to check in or something like that. Many of the airlines or the carriers are working with that, with the integration of this system with that. As soon as you check in, put your passport number, it will try and hit and try and find your status automatically. So you should update your new passports, any ID documents, anything that changes as soon as possible. That is my advice. What is the timeline to update? And if you are asking, you have applied for a new e-visa account, if you created a visa account and you have not got the e-visa email yet, your e-visa is ready. I think usually some of them get within a week or so, but I've seen up to 4 weeks on a higher end. So to get the email, your e-visa is ready to view now after you create the UKVI account. Just sharing the share code is sufficient during immigration right. Immigration right. So if you are thinking of talking of right to work, right to rent, etc., yes, just the share code is sufficient. And I think your date of birth or something that you have to give to your employer or landlord. Right. Okay. And thank you very much, everyone. I have to go and pick up my kids from school, so I have to end this live now. And thank you very much, whoever joined. I will try to do one live per week if possible. Try to schedule that in advance. Yeah. Thank you.